and getting a better understanding of why the Judicial Inquiry Board really should not be expected to be the superhero in any matter where you report an acting judge is very simple. One is self-responsibility. If you really want to hold someone liable, you will have to do it yourself. You'll have to do it in a personal capacity. And two, really when you look at the details of the 1970 version of the Illinois Constitution that creates the Judicial Inquiry Board, it's really more so a mitigation matter, not really holding them liable per se. But really the intent of you doing this should be to approach things from different angles, just as they do with you. Always attack from different angles, because they do the exact same thing with you. With probation, with pleas from other cases, career offender, or they prohibit you from doing certain things based on other cases, things of that nature. Use all the tools and the options that you've got. Kind of makes the acting judges sit upright if they're slouched and comfortable and just pointing fingers everywhere. It makes them sit upright and act right. Of all the circumstances where these reports have been made to the judicial inquiries, only once have I seen an actual case number. That is because the Judicial Inquiry Board is a separate entity that makes the claim on behalf of whatever facts that you present. So you're going to have to structure it just like a regular complaint, but specific to just the judge and the mitigation of the administrative agencies. And you will have to bring facts in. You have your stenographers, bring it in. Sometimes the facts are really as easy as their oath of office, your acceptance of it, and your affidavit. And sometimes their own self-confession with the orders that they put in. Because most of these acting judges are very comfortable. Very, very comfortable. So they will write things down in a manner that's that of trickery. They always do that. That's a norm that ought to be expected. But all you really have to do is just slow down and look at it, and it reveals itself to you. Nonetheless, the Judicial Inquiry Board takes up the complaint on behalf of the facts that you present and then hands it to the courts of commission. And when it gets that far, they then issue complaint, case number. And in your judicial inquiry, the misconduct reports, you should always request for a case number. So I'm better understanding what these guys really do as to why and how they're not gonna save you, but more so you just utilizing the tools that's necessary to basically mitigate the matter in your favor, and to let things be known that there are many eyes on what is going on. Remember, you are perceived as a victim. You're not a victim, but those taking advantage of you approach you as though you are. And oftentimes, the more eyes are on the situation, even if it's with fellow friends or partners, the more eyes is on a situation, the less likely that bully is going to be willing to engage in those consistent or perpetual behaviors as it was done previously with others, or as it has been done with you. So, what will be some of the claims you make as to the reason why you think it's necessary beyond your facts? Just basic common sense. Public confidence, the honesty and integrity of the judicial system is a factor absolutely central to a free society. It's a very simple phrase, carries a lot of weight. In other words, in order that frequent recurrence of fundamental principles, individual rights, free government is instituted amongst men is upheld and is sworn by whatever the acting judge is, you're demanding that the representatives of that mitigating administrative agency proceed the matters to be heard within the court's commission. You're basically doing things in good faith to get things exhausted in that realm. Not that you're expecting them to come and save you, because ultimately you would have to do that. But nonetheless, it is one extra box that is ticked off. It's one extra tool that you can use, and you should use. Then goes on to say, under the 1970 Constitution, which is the amended version that created the Judicial Inquiry Board, the Judicial Inquiry Board has neither the right nor the responsibility for determining the guilt or innocence of a judge of any particular charges which may be made against him or her, or to impose sanctions upon any members of the judiciary. The board express constitutional mandate, meaning their limitation of power, is to conduct investigations, receive or initiate complaints concerning judges. So the reason why, so they let you know right here, we cannot reprimand them for anything, for any reason. So you should not have that expectation when you create these judicial misconduct complaints. Be honest with yourself right from the start as to what you're doing and what is going on. Although their responsibility, if you bring in the facts right, is to conduct investigations, receive initial complaints concerning judges, and determine whether a reasonable basis exists to file and then prosecute a formal complaint with the court's commission. What is this reasonable basis? It's based in the Constitution. Those Bill of Rights, that is a reasonable basis. And as expressed in other videos along these, series, is the Code of Judicial Conduct. When it comes to bias, when it comes to disrepute of the office, and when it comes to using the prestige of office to grant special immunities and privileges. So you don't have to use these specific verbiages. Those reasonable bases is always going to be based on the Constitution. And one of the most no-brainer things that you will see very frequently with any type of complaint is when it comes to, alleged public officers and whether they're acting in their capacity or as a public official or in their personal capacity. One consistent factor is, well, did they actually engage in these acts because of your constitutionally secured right being enforced, or did they do it in their public capacity? So you have to state the claim. As much of a no-brainer as it is, you literally, whatever the name of the acting judge is, You don't have to use this exact verbiage, but whatever applies to your circumstance, just list it. Whatever the name of the judge is, known actions herein were motivated, substantially caused by exercise of my preserved right to speak and appear on my own behalf, or with counsel of my choice, or without a British accreditation registered member. Exercise of my preserved right to freely speak, exercise of my preserved right to be heard, exercise of my preserved right to redress and grievance by invoking habeas corpus and sufficiency of allegations to qualify as a fugitive, exercise of my preserved right to secure to my private properties in effect. Whatever the specific instant matter is that deals with you as prescribed by the Bill of Rights in your state, list it. If you don't say these things and you just go on and on about what's going on, they're gonna go, okay, what is the intent? Why did he actually do? What is the fact? What's the factual allegations of why he's doing all these things? You have to state why, and this is why. It's that simple. And then, of course, always use the maximum of law. It would always benefit you. Now you're asking yourself, what compels these acting judges to sit up straight and to begin to use common sense? Well, it's simple. This is what they do when the Judiciary Inquiry Board chooses to mitigate the matter. It says immediately prior to the filing of a complaint with the Courts Commission, meaning, keep in mind, this is not you. This is this administrative agency picking it up and then doing their administrative thing. Remember, as odd as it may sound, in certain things that cannot be expressed in this venue, if you do your research well enough, you'll find it. But these people, they don't like each other. But nonetheless, immediately prior to the filing of a complaint with the Courts Commission, the respondent judge and his chief judge are notified by the board. Why chief judge? Because the chief judge oversees the judicial conduct of this guy. The chief judge cannot make determination of each case because the associate judge or the regular judge is deemed to be competent enough. But whatever it is, trespassing against the Constitution, of course you would always carbon copy the chief judge, and they by inference let you know that too. So read between the lines and know who you send carbon copies to. When the complaint has been filed, copies are given to the News Bureau in Springfield and Chicago for dissemination to the news media. If there's one thing that tortfeasors do not like, if there's one thing that people acting in public official positions do not like, it is publicity. I have personally yet to figure out why, but they hate publicity. They hate the news. Hate is a strong word, but that's exactly how they feel about it. I can presume that it's bad for business, but who knows? Maybe there are other things involved. The board responds to the inquiries regarding complaints it has filed only by giving factual information regarding the allegations as set forth in the complaint. Meaning whatever you give them is the only thing that they're going to view as a validating factor or as a qualifying factor for them to take it up and then begin to mitigate the matter, or for them to take it up and deal with the matter according to their administrative procedures and the Administrative Procedures Act and the Administrative Review Act. So you must always bring in facts. Don't screw around, don't pussyfoot. Get to it. It will not elaborate upon the charges except in the proceedings before the court commissions, which are public. This is the reason why you should always use that Bill of Rights as your foundation and your reasonable cause for making these Judicial Inquiry Board complaints. Because it takes it back at 360 degrees. Yes, these are administrative agencies. It's very obvious. But nonetheless, no administrative agencies can function or exist without the power of the Constitution. And the ones who creates that power, or at least who has that power that created that Constitution, is you. You listening to this. So these are tools that allows them to act very similar to a home rule unit, but you can still always kind of remind them, hey, listen here, we can take this on a personal level and begin to go after you, but let's just do this first to exhaust our remedies. And usually the case will end in your favor quick. The worst case scenario is that they will issue court permission case number. I've only seen that happen once, and that will usually happen if the acting judge is, functioning in the South. If it's about an egotistic thing, and when that happens, it's like they just can't help it but keep incriminating themselves. I don't know why that is, but they just can't help it. And then you, of course, in your initial complaint with the judicial inquiry, you reserve the right to amend it or create addendums to it. And then you can always create addendums. But oftentimes most acting judges are not that naive to prolong the matters. And here's another very important thing. When that case is dismissed, which if you are a defendant, that's what you probably want, that would automatically close the matter with the Judicial Inquiry Board. Just keep that in mind. But nonetheless, that's all you need. That's what you want.